Hello and welcome to ICA in Conversation that broadcasts on the second and fourth Wednesdays of each month, focusing of course on current issues and challenges in the context of compliance and counter financial crime. I'm Tim Tyler, and coming up we're going to consider the labyrinthine nature of fraud investigation and prosecution. To set the scene, we've seen in the last weeks the publication of the long-awaited report into the UK Post Office fraud inquiry. As many as 13 individuals took their own lives as a result of deeply flawed fraud inquiries. Separately, we're seeing once again in the UK formal recommendations that complex fraud prosecution should be considered not by a jury but by specialist judges. And we anticipate once again in the UK new legislation that will simplify and extend the Crown's ability to prosecute companies as well as individuals. These are, of course, UK developments, but they reflect the same challenges being experienced in the investigation and prosecution of fraud across the world. So I'm delighted to be joined by Andy Clarke to consider these challenges. And over the next 30 minutes, we're going to unpack what it is about fraud that makes it so complex and challenging, and some of the ways in which this is being addressed. Andy and I have spent much of our careers investigating and overseeing the investigation of complex fraud. We've both moved on to wider roles, including, in Andy's case, leading the ICA's financial crime prevention capability. I think it's fair to say, though, that both of us have retained our passion for this subject, and I've been looking forward to this conversation for some weeks. So, Andy, thank you so much for joining us.
Thank you very much, Tim, for inviting me. I'm looking forward to this.
So, as ever, the format will be 20 minutes discussion, followed by an opportunity to respond to questions and comments that you may make. And I'm keeping an eye on the comments on the LinkedIn item that we're currently viewing. And here's an opportunity for you to raise any questions or observations that you may have through that comments section. But let's make a start. And Andy, can I start by asking about this idea about complexity of fraud investigation and prosecution? How is this, and why is it so complex?
The fraud often has a complexity that's not present in many other crimes. I wouldn't say all, certainly, but many other crimes. And even a basic fraud can entail the gathering of a lot of evidence, of a lot of different forms of evidence. Fraud is very rarely a spur of the moment thing, and people might see an opportunity and take it, but generally fraud will have some planning behind it, and that planning also might include an element of how to respond if discovered. So they're more prepared, I suggest, than in many other types of crime. So when you have a complex fraud, there can be vast amount of material. So transactions that have taken place, financial transactions, digital forensics, often accessing systems, action that's taken once an individual is in system, the witnesses that need to provide that as evidence, the sheer volume, even if held digitally. So we're not talking about an old school, huge paper file, but even held digitally, it's a vast amount of material. And that all has to be examined for disclosure purposes, reviewed by the defence. That brings in a significant delay. So a complex fraud can eventually go to trial, maybe 2 years down the line, which is one issue. And then when it arrives at trial, you mentioned the jury recommendations, but when it arrives at trial, you then have a jury that might have 2 months of listening to evidence, expert witness evidence, forensic accountants, other experts. And that's a real challenge, unless as an individual they've got a background that's relevant. Most haven't. So it's a real challenge for them to understand the evidence. And without that understanding, how can they be confident enough that the threshold of beyond reasonable doubt has been met? So that's a couple of points, I think, around that, which is the current situation.
So I know we've both worked in similar fraud inquiries, and the number of witnesses can run into the hundreds of witnesses. The
Certainly.
information can be incredibly complex. The volume of material can run into, well, of course, as you say, going back to paper files of literally hundreds or even thousands of crates of evidence that we were sifting through. Now, of course, it's digital, and that brings its own challenges because you can't ignore anything. You can't, for disclosure purposes, you can't just pretend it's not there. So you have to review it. You have to show how you've reviewed it, and the whole process needs to be transparent to the defense. So the scale of this is enormous, and I guess we shouldn't be surprised when prosecutions fail, when they're played out before a jury, because of that complexity, the number of witnesses and the level of information that needs to be understood and absorbed in order to make sense of it. But can I just draw on your experience a little? When we were running up to this conversation, we talked about your experience when you were leading a fraud squad in South Wales, I think. Have I got that right?
Yes.
And you undertook and your team, a range of quite complex fraud inquiries, as did I in Cheshire and the National Crime Squad. And one of the challenges, of course, is reining the team in. They get carried away with, all so much that's happened over many years that shows dishonesty of the principals, that colours their character and things that we want to show. But this can then lead to, I think we called it scope creep. The inquiry just gets bigger and bigger and bigger, and it takes longer and longer. You had a really interesting way of addressing this that we spoke about.
Yeah, I think just to take it back a little, the focus on how we address the challenges of complex fraud has been, I think, on the trials, and we've got the Leveson report suggesting an alternative to jury trials. But I would take it right back to that point you're making, right back to the very beginning of a fraud investigation. The victim has made the complaint, the initial sort of scoping exercise to understand what we're dealing with, what we've got. There's a complex fraud element to that, but there's also something that I'd call fraud made complex, where there's a subtle difference, because I think taking a far more focused approach at that beginning, and what you're alluding to there, at that beginning point, will then lead to a more focused presentation of evidence before the jury. So it has benefit right the way through. But there is that sort of cultural challenge with fraud investigators, and as you said, they traditionally they want to show, we've got to show the whole scope of the criminality. We've got to show everything that this person was up to. Well, no, if we can focus it, the UK has got a very robust confiscation regime. So if we can focus something that is some charges on an indictment that presented to a jury that's far more understandable, they can be confident they understand it and to convict. And then from that point, use the confiscation to scoop up all the remaining criminality and that individual's assets that they may have, to then show the scope of their criminality. So I think there's opportunities there, but it really relies on that first point. And what you're saying about reining investigators in, what I did in one case when it was first reported, I asked our fraud analyst to provide a pictorial representation of the investigation.
Anna Kappa chart, wasn't it?
Yeah, Anna Kappa, IT. Yeah. So it had suspects, associated persons, professionals being used. Might be enablers, might not, lawyers, accountants, and the like. And the main lines of inquiry, and it had it on this chart, this printed chart, and I put that on the table, and I got a red marker pen, and I drew a circle around the part in the middle, and I said, we will comply with the legal requirements to follow all reasonable lines of inquiry, but our focus will be there. And as you can imagine, there was a few red faces and coughing around the table because that was non-traditional. But I think if you can take that approach, then as it goes through the process, as long as you avoid that that barrister that wants to turn everything into a conspiracy, which we probably all know. As long as you can keep it focused right the way through, then there's an alternative way. And there is nothing unethical about considering confiscation. In fact, the director's guidelines for CPS lawyers actually say that you should consider confiscation opportunities within the public interest test. So it's fine to do it.
So let me pick up on that, if I may. There are confiscation provisions all around the world. FATF is increasingly focused on asset recovery as a key measure to take to counter money laundering. Again, drawing on your experience, have you been able to prosecute something relatively modest but generate significant confiscation on the back of that?
Yes, there's a number of cases like that. I've actually got one of my investigations which became case law in that very area, and that's called RB Steed 2011. And what happened in that case, the defendant pleaded guilty to tax evasion as an alternative to money laundering, and the level of tax evasion, the total of it was about £6,500. That was the fraud, tax evasion, tax fraud. £6,500. But when we applied the confiscation processes, the benefit figure, so their wider criminality, came out over £800,000, and their available assets, which could be taken from them, was over £700,000. So that's a classic example. And that case law, I'm quite proud of that, because that case law is now used and cited very often in confiscation proceedings to say that the scope of the benefit, the scope of the confiscation, will very often extend beyond merely the this charge is subject to conviction.
Which is a really compelling argument to stay focused in what you charge. You don't need to charge the 700,000. We can still recover that if the assets can be identified. And that's an amazing case. From experience. Criminals don't like giving up their assets, do they? They'll kick and fight and they'll do everything rather than allow it to happen. Can I just provide a slight counter, though? I'd like to move on, but this idea of complexity, and absolutely agree, the opportunity that we have to keep it really sharply focused, but that won't necessarily ensure that there isn't complexity. And let me give you an example from my experience where there had to be a high level of complexity, otherwise it wasn't possible to prosecute. And in this particular instance, victims were sold, and this was in the many millions of pounds, victims were sold investment opportunities, but without really being told very much about what they were. And that's not unusual. And the criminals took the money from that investment opportunity and then recycled it into buying a gold ore, a used gold mine in the United States. It had been used, it had been dug out, but there were just piles and piles of used gold ore that had been processed. Then they hooked up with an inventor who claimed to have developed a process to recover more gold from processed gold ore. And then and it was, to be honest, the guy was a little bit wacky on this. There wasn't really any genuine effort behind this. But they then just did enough to buy the gold mine for virtually nothing. They hooked up with this guy and then started just to talk about processing it. They never did anything with it. But then they went a step further and had the whole thing launched and floated on the NASDAQ in the stock exchange in the United States. So we found that in order to show the dishonesty and to take it right back to square one, not only did we need to unpick the initial investment and the rationale for it, we needed to unpick the gold mine, the rationale for it, the fact that this inventor was not really proposing anything significant, and then unpick the NASDAQ flotation. Because of the way that you mentioned before, that fraudsters will sometimes plan their activity. Yes. But here I'm speaking too much, and really we're much more interested to hear from you,
I think
Andy.
A couple of words you said there I'd pick up on when you said in order to show. And I think that's key. It's how the evidence and the complexity is presented to a jury. And I think we've got real opportunities here. Occasionally, it's presented in a more modern way, if you like. But in other crimes, many other crimes, a jury will see CCTV evidence or something visual, which carries a lot of weight. So I think with fraud, we're missing the opportunity to present better to a jury so they can understand it. So we could be using the link analysis that I mentioned earlier, actually using that it's almost exclusively used to show links between individuals. So a link between the main defendant and their lawyer they were using, or something like that. But it could be used far more effectively to show the link between evidence and make it more understandable. Use infographics, use AI, and AI to summarise most witness statements. You could summarise in one line. So that sort of thing. I think we're missing an opportunity there. It is used occasionally, but that's very much down to the individual.
I agree.
So
and I think there's another element to this, which perhaps I have to tread carefully around, but we need trial judges who are strong enough to say, that's the position, they are accepted facts, that infographic accurately represents the issues. Because, of course, what defense attorney or defense counsel will often do is just try and muddy the waters, try and make it more complex than it is, try and make it difficult to understand. So the trial judge becomes a really important component within this, because for us to use AI and infographics and other ways to demonstrate the information, then it needs for that to be accepted, and a canny defense counsel can just run interference on this.
Yeah, I think that's a good point. I think I'm quite pragmatic on that, in that the defense counsel, that's their role, is to test the evidence, and if they do make it less understandable to a jury, well, that's something the prosecution has got the responsibility to make clearer.
Yeah, I agree.
But also, I think that takes us onto the point of the Leveson with, and that's been talked about for a long time, hasn't it? Complex frauds being dealt with by, without a jury. I'm actually more in favour of a panel rather than a single judge. So maybe have a judge to interpret the law, and then have the very individuals that would be expert witnesses. So depending on the case, a forensic accountant, tax specialist, that sort of thing. Although I am torn on that, because I, without going off on a tangent, I do think that once you take that step, it might be crossing the Rubicon and then not back, because we've had that since 1215. We've had the right to trial by peers. So
going way back to Magna Carta, this idea of
trial
by jury is foundational.
I'm a little torn on that. You chip away at one thing, and that's a precedent.
The counter argument might be that there are other countries, like Germany, for instance, where it's just a panel of judges. And I'm sure they would argue, I don't know, but I'm sure they would argue that it works very well there, and it hasn't actually unpicked the criminal justice system. But it is
something maybe a step towards that would be specialist courts. And in the Emirates, there are specialist money laundering courts.
Yes.
So would I have specialist fraud courts? I know there's a capacity and financial implication to that, but to have a specialist fraud court where everyone involved is more familiar with the nature of the offences.
Yeah, it makes sense, doesn't it?
Handling of brass bodies with exhibits and that sort of thing.
A quick reminder to you, wherever you are, in joining us, and it's fantastic to see colleagues from Morocco, Switzerland, the UAE, Mozambique, Ethiopia, Tunisia, Dublin, and Brighton, a little bit closer to home. Thank you very much for joining us. But please raise any questions or observations that you have through the chat function or through the comments, and we'd love to be able to address them. But I'd like to move on for the moment. Another way in which the investigative process and the prosecution process is arguably made less complex is through some of the changes we're seeing at the moment around the doctrine of identification. I know this is something that you feel quite strongly about, Andy. I wonder if you could talk us through that.
Well, traditionally, there's been an approach, and for the benefit of those who are not from the UK, the identification doctrine, the threshold for proving corporate criminal liability has been that there must be evidence to prove the controlling mind of the organisation. And this is very difficult. It results in a playing field that's not level, because it's quite relatively easy with an SME to show that those at the most senior position in the organisation were aware of what was happening. But you can imagine if you're watching this and work for a global tier 1 bank, proving at the highest level of individuals They were aware of the sanctions evasion, the staff involvement in money laundering, active money laundering, that sort of thing. It's virtually impossible. So what's happened in the UK is that threshold has been changed to, rather than control in mind of the whole organisation, has been changed to senior manager. Now, this is not the first time this change has taken place. In relation to corporate manslaughter, that was done previously with legislation. But now what we've got is legislation for economic crimes, which changes this threshold to senior manager. And that list covers all you can imagine of economic crime: fraud, money laundering, tax evasion, some regulatory offences. Misleading a regulator is quite an interesting one, I think. So if that criminality by an individual has taken place and a senior manager was aware, that then will bring in the corporate liability of the whole organisation. So that's something that is in now, and it's something, Tim, I think has been overlooked because big focus on the new offence of failing to prevent fraud. Quite rightly, that's important, but that seems to have overshadowed. And I very rarely hear people talking about or considering in their compliance strategy this new corporate liability. And I think it's a vulnerability. I think it will open up the door for more prosecutions. In fact, I will mention, Tim, that a couple of weeks ago I was at the AGM of the Fraud Advisory Panel, and the guest speaker there was Nick Fgrave, who's the current director of the SFO, appointed fairly recently. And
Serious Fraud Office, so just as you're going there, Serious Fraud Office, if you're outside of the UK.
Sorry, I should have said, the Serious Fraud Office, who deal with the highest levels of fraud and corruption in the UK. And he was very proactive on using this new level of corporate liability. It's unsurprising considering he's got a police background, but he was very proactive, and he actually said they're enthusiastic that they will provide the case law that defines what a senior manager is. But they are pushing it forward. So we will see, inevitably, more prosecutions. And just a point to add on that, we've considered economic crimes. There's another bill that's going through the UK Parliament at the moment. At the moment, it's sat with the House of Lords, and that's the Crime and Policing Bill. That will make this change of corporate liability to every crime. So firms that were involved in the dumping of toxic waste, another environmental crime, firms that are employing workers in the nature of modern day slavery, all of those crimes will now result in corporate criminal liability being more easily achieved and in a less complex manner. Back to the complexity.
And of course, we're talking here about the UK, but it's worth highlighting that across the world, we're seeing regulators that are holding companies to account to an increasing level, whether that's through regulations, through civil process, or through criminal process, as we're talking about here, can vary. But the principle holds that regulators are looking to hold companies to account, and of course, looking to hold senior individuals within companies to account at a personal level as well. As a really interesting trend that we're seeing developing around.
I'm really pleased to see that, because I think I'm a real believer that accountability acts as a deterrent for crime, particularly with corporate crime. It acts as a deterrent. If that senior manager realises that they will be held to account, then it might just, or any individual, it might just tip the balance when they're carrying out that risk assessment of what's the chances of me getting caught, and if I did get caught, what would happen to me. So increased accountability might just tip that balance so that the individual doesn't go ahead with the actions that they're thinking of.
Makes sense, quite. Interestingly, I'm not seeing any questions, which is unusual on the chat function. And I see my colleague in the room, my producer, is nodding, so I think that's right. So let me ask a question then that perhaps takes us in a slightly different direction. Something else that Nick Fgrave and others have emphasised recently is the need to be more proactive in our approach to fraud. Now, let's put that into context. We both know, of course, that typically, historically, we've started with a fraud having taken place with a series of victims, typically, and then we would investigate that, make sense of it, determine whether a crime has been committed and who has committed that crime, and then we would build evidence against them. That's, if you like, a reactive approach that reacts to what's happened. There is opportunity, I think, to take a more proactive approach. But what might that look like Do you have any thoughts around that?
Yeah, I think it's back to deterrence. I think if you can influence an individual's thoughts about what's the chance of me getting caught and what will happen to me when I do, if you can influence that, that could be towards an employee who may be considering submitting a false expense claim. It could be to a customer of a bank or any organization, any firm who is thinking of committing a first party fraud, a customer fraud against the bank. It could be because of totally independent from a business, of someone who's thinking of tackling a potential victim, an individual. If you can influence that, it's I think that the criminals, particularly sticking with the fraudsters, I think they do have that thought process. It's a form of risk assessment.
Yes.
They don't record it as we do with fraud risk assessment, but I think they do go through that thought process. Maybe it's like an opportunities assessment. Going back to what's the chance of me getting caught? If I do, what's going to happen to me? And if you can influence both of those things, then I think you can have an impact on fraud. So I think the deterrence, the fraud deterrence, is something that to me is more proactive than waiting for frauds to be reported. By that point, we have a victim, we have something that's devastating that's happened to a person or an organisation, and we're reacting to it. I think being more proactive and tying that in with the compliance approach, the fraud prevention approach in businesses, being aware of that fraud is it's obviously an important issue, but being aware that it's an issue that we can impact on.
Yeah. So can I offer a slightly not a different but another view that complements what you've just said, and I'm going to draw on my experience. I over a number of years I investigated what was then called a prime bank guarantee fraud, and you'll be familiar with this style of fraud. It runs into millions of pounds, really complicated explanations around how the investment is going to grow, that involves interbanking transfers and so on, and it's just a nonsense. However, fraudsters were making tens, hundreds of millions of pounds from it. Well, I spent a number of years investigating one. I traveled all over the States, as far as Hawaii, all over Europe at different times to try and prove, to identify the victims, to gain evidence and so on. And we were successful, but it took a number of years. And along the way, I met with an agent in the FBI working out of the office in Sacramento, he took a proactive approach. And that's the reason I mention it. And so his approach wasn't to investigate what had happened, construct it and present this evidence to a court. He started with the individual. So when he knew who the offender was, he literally wrote to them under his own name to say, I am a special agent. Can I tell you that this thing that you're doing now, for these reasons, is a fraud? Can you just acknowledge receipt and that you understand this? And typically the fraudster wouldn't reply. So he'd write again and write again. And eventually they would reply just to make him go away. And they'd typically sign to say, yeah, okay, I understand X, Y, and Z. That amounts to a fraud. I haven't done anything though. I'm completely innocent. Go away. So then the agent would wait a few weeks, maybe months, and then would put a participating informant. So this is someone outside of law enforcement who's acting on instructions of that agent to approach the individual and just casually mention that they've got several £1 million they want to invest and see what happens. And of course, because the individual's a fraudster, they can't help themselves. They offer the prime bank guarantee investment or something similar, and they try and persuade the individual to invest. And here's the interesting, and here's the killer point, of course. As soon as they've done that, it's been recorded because the informant was mic'd up. They've got documents that the individual has provided to say this is what's going to happen to your money. And all the agent then does is put the three things together: the recording, the testimony, the evidence from the witness, and the fact that he's signed a document to say, yeah, I do appreciate that X, Y, and Z would be a fraud, and that's sufficient to convict. And so he can do that in the space of a week. So this, I think, just illustrates the potential to take a different approach to it. But
I think that reminds me of a term that I heard with the Proceeds of Crime Act it began really about 2000 with the Cabinet Office, and then we saw the bill going through. So if you read Hansard in relation to it as the bill was going through Parliament, and there was a term that was used which I think was just sort of sums up that. And the term was lawfully audacious.
Lawfully audacious, yes.
And that
Brilliant.
they expected the legislation to be used
Yes.
in a lawfully audacious manner.
Yes.
And as a term, I think that's great in terms of deterrence and proactivity.
Yeah, fantastic. We're coming up towards the close, but there is one question. They've come. My apologies to colleagues around the world who have now asked some questions. I'm afraid we're running out of time. But Emma Jespersen, thank you for your question around bigger corporate. It's a really clever question, actually. And Emma asks, is it possible that bigger corporations will introduce more complex management structures in order to protect themselves from this controlling mind, or what was a controlling mind requirement? So the legislation, I think you set out, is senior manager. It only requires for them to be aware of or to be involved for the entire organization to become guilty. Emma is saying, well, do you think organizations will...
That's a really interesting question, because I think events and legislation's overtaken us because we've got now the senior manager threshold, and that's going to be introduced for all crimes. But I think if an organisation was found to be creating a management structure in order to distance themselves from any criminality, there could be an implied knowledge or suspicion of that criminality taking place. And I think if that was a regulated firm, I think that would be bode very badly with the regulator uncovering that. So I think that historically, maybe that's taken place if, because we know some organisations are systemically corrupt, some organisations are systemically involved in tax evasion. So maybe that restructure there that was mentioned in the question would actually provide evidence of knowledge of that controlling mind.
The difficulty, of course, from experience, the difficulty here is how do you demonstrate to a court that the reason for that restructure was so that they flew under the radar, and because it's not going to be recorded in the minutes of the board meeting or whatever.
It's not, but maybe you could have some sort of contact, like in sanctions evasion cases, literal evasion, not system failure. The sanctions evasion cases, there's been email records of people saying to legal department or senior managers, I think this is illegal, we shouldn't be doing it. No, carry on. So although it won't be minute recorded, I think there may be, but then that's that volume, that's back to complexity, that volume of information that needs to be considered and processed to discover that.
Makes sense. And that's where we started, of course. So you've brought us right back to where we started. I feel quite bad because there are some wonderful questions that have been raised. Heather, it's great to see you joining us today, Heather Worcester. Assad, thank you for your question. And Victoria, 4 really challenging and quite probative questions, but I'm afraid we've run out of time. But before we do wind up, Andy, can I just ask, is there any final comments or thoughts, any practical things that you'd like to leave us with before we draw this to a close?
I think in terms of organisational resilience to fraud, it's very often said in training, be aware of the latest landscape, horizon scanning, that sort of thing. I think it's not to be maybe distracted by one particular thing, like I think I'm seeing now, is the failure to prevent fraud as seized the attention. So I think in terms of organisational resilience is to try and be aware of everything. And something that I'm pleased to see emerging in recent years is that the whole fraud environment, counter fraud environment, is being treated more seriously. It used to be the poor cousin of AML and other areas. Now I think it's, and that's something I'll probably finish with, and that we're going in the right direction. I think it's good.
Yeah. Okay, thank you. And thank you again for joining me today for this conversation. And thank you to colleagues around the world for joining us to listen in on this conversation and contribute to it. I'm sorry I didn't get to all the questions, but perhaps we'll do this again, Andy, if you're in agreement.
Yes,
and
please.
we'll pick up perhaps where we left off. But in the meantime, do take care, everyone. Thank you.